Good morning, everybody, and welcome back to the Prestige webinar series. And this is where we bring you the updates and as much need-to-know information as we can in order to best navigate the growth of your business. My name is Melissa Analfo. I'm the Supervisor of Client Success and Operations here at PrestigePEO and also your host. This morning, we are joined by special guest. We have Tom Stoller here. Tom is the Vice President of Federal Government Affairs at NAPEO, also known as the National Association of Professional Employer Organizations. Now, today, Tom is going to be here to discuss the White House's OSHA vaccine mandate for private employers affected by the path out of the pandemic. We discussed this last webinar with things potentially coming down the pike, and we are pretty much continuing that conversation with just where the status is. So Tom is going to cover the current status of the ETS, what is an ETS, right? The emergency temporary standards and the regulations as they stand today. Now, as always, participants are muted. We do encourage you to use the Q&A feature in the chat. If time allows, we will have an opportunity to hopefully answer or touch on some questions to see what, we can answer right now. So please utilize that while you can. If you need this information after today, this recording, along with all of our others, will be posted, as always, on our blog, The Prestige Perspective. So that's www.prestigepeo.com/blogs. Now, with that, I'm going to call up Tom to come join me on the phone here.
Thank you. Can you hear me?
We sure can.
Great. Well, thank you, everyone. Welcome. This is an interesting webinar because normally you would go over, a proposed rule, what it is, where it stands, and the next steps. The court ruling on this really has kind of turned it all upside down, and the status is actually more important at the moment than what's in the rule. So I thought I would kick off with that to kind of explain what's going on and where things are, because it kind of tees up everything else. So, I've never used WebEx for a webinar, so you'll have to help me with the advance on the slides.
Not a problem.
Okay. So the current status of the ETS, it was released, I believe, about less than 2 weeks ago, almost 2.5, maybe 2.5 weeks ago. It was immediately, there were lawsuits in multiple court jurisdictions in the country against the emergency temporary standard, and it was almost immediately stayed by the Fifth Circuit. And the Fifth Circuit it includes Texas and Utah and a couple other states. Over the weekend, the Fifth Circuit made the stay permanent. It's a 22-page opinion. It's actually a fairly easy read, a non-legal read. Encourage you to go read it. They basically slapped OSHA pretty hard and said, we don't think you have the authority to do this. We think you're going to lose this case, and for that reason, we're going to put a permanent stay on this rulemaking. Now, when you have a lot of lawsuits that come in against a rule in multiple circuits, the federal courts hold a lottery to determine which circuit all the cases will be consolidated under and heard. And yesterday they held the lottery, and the cases were assigned to the Sixth Circuit Court, which is Kentucky and several other states in that region. So the Sixth Circuit is now going to hear all the cases that have been filed against the OSHA emergency temporary standard. They also, so now there's two parts to this rulemaking that are in court. There's the stay. The Sixth Circuit can lift the stay, they can make the stay permanent, or they can issue a decision which renders the rule, which basically says the rule was incorrectly issued, and that would be the equivalent of stay. It would eliminate the rule. I don't know what they'll do. Nobody knows what they'll do, because they have to assign the case to 3 judges, and then the 3 judges will hear the arguments, and then they'll issue their ruling. It could be fast-tracked to the Supreme Court. I'm not sure if the stay can be split from the case itself and fast-tracked to the Supreme Court, but that is a possibility, I believe. And if that's the case, the Supreme Court could rule on the stay, and that's could get tricky because there are some judges on the Supreme Court that do not like federal circuit judges putting national stays on regulations. So It's a mess. I think that's the technical term for this. Is it's a mess. And from a timing perspective, it could be anywhere from weeks to months before the courts settle this. Um, and that's what makes things complicated as an employer, because you're supposed to be in compliance with this rule on December 5th. So go on to the next slide. So what is an emergency temporary standard? You know, in Washington, D.C., agencies go through rulemaking processes. They issue notice of proposed rulemakings. There are comments on them. The comments are put in the record. The agency responds to the comments. Then an agency issues a final rule. And then occasionally agencies are sued for the final rule. They have to be sued based under the Administrative Procedures Act. Or if the litigants believe the agency has reached beyond the powers that the agency has, they can sue on that basis. In the Occupational Safety and Health Act, there's a provision that allows OSHA to issue emergency temporary standards if the agency determines there's a grave danger to worker safety. Now, grave danger is not defined in the Act. Grave danger has never been defined in a regulatory sense. There's some cases from the 1970s that tried to define what grave danger is, but the reality of it is there's no legal definition of grave danger. An ETS does not go through typical rulemaking. By its very nature, it's an emergency standard. So as soon as it is published in the Federal Register, it becomes a final rule and you have to comply. According to statute, it's in effect as long as the grave danger exists. But the ETS is also a proposed rule. So this is kind of the weird part of it. It's a temporary rule you have to follow, but it's also a proposed rule that the agency has issued, which you can comment on, and the agency has to respond to. And then in 6 months, that becomes a final rule. So the emergency rule transitions into a final rule as a draft rule. So it's not a normal rulemaking process from the federal government. So OSHA has issued 11 of these, and OSHA was created in 1970, and in its 50-year history, it's issued 11 ETSs. Interestingly enough, there are 2 this year. 4 of them were stayed by the courts and struck down, and 1 was partially stayed. And this is prior to this year, so half of them were struck. And OSHA had not issued any ETSs since 1984, and that was actually one they lost. It was struck. And the agency has been very hesitant since then to issue an ETS because it is a lot of legal work for the agency to do for something that's temporary, when typically their normal rulemaking process gets better results for the agency. So this is a unique rule. It is a seldom used rule. And one of the issues in it, obviously, if you look at the court cases, is COVID a grave danger? And that's one of the issues they're going to fight out in court. So next slide. So the OSHA ETS, and as I do this, I'm going to go through it at a very high level. I would recommend, if you have really detailed questions, your first stop should be the OSHA webpage, osha.gov. They've got a really good FAQ section. They've got really good descriptions of the rule, of what employers are expected to do in detail. They actually did a really good job on this for employers to read and understand what's expected of them in this rule. So I highly recommend the OSHA page, osha.gov. But basically what the rule is intended to do is establish a minimum vaccination and vaccination verification, face covering, and testing requirements to attest COVID-19 in the workplace. The other thing it does is it preempts all state and local COVID-19 workplace regulations and standards. So for example, the rule is explicit in banning what Florida and Texas have done to prohibit employers from testing employees. And that is part of the rule. And they're very, very specific in doing that. So go ahead to the next slide. So stuff I think you all probably know or heard. It requires private employers with more than 100 employees to either mandate employees be fully vaccinated against COVID, or required employees who are not vaccinated to take weekly tests and wear face covering. Now, from an employer standpoint, you are required to establish and implement and enforce a written policy on vaccines, on testing, on face covering. You need to provide this information to your employees. You have to provide paid sick leave off to employees receiving the vaccination and paid sick leave if there's any adverse reactions to the vaccination. You have to obtain and maintain records proving employee vaccination status. Also, you have to keep the same paper for medical and religious exemptions. And you have notice requirements in case somebody within your workforce comes down with COVID. And you have to report that as well as keep it on your OSHA logs. So I've done that. You have to report to OSHA also if there's a hospitalization or a fatality from OSHA or from COVID. Next slide, please. So the coverage, it's all private employers with 100 or more employees. There are some exceptions. If you're a federal contractor, you have a different set of rules. You actually have a federal mandate if you're a federal contractor that your employees must be vaccinated. Otherwise, you cannot be a federal company. Otherwise, your federal contract could be at risk. There's also a second ETS that went out for healthcare workers in June. If you were covered under that, this ETS does not cover you. The new one, you're covered under the other one. There's also, in addition, some HHS and CMS regulations you have to comply with. Next slide. Now, there are exemptions to the coverage for those who have 100 employees. So if you're in a workplace where there's no one else present, like there's a single employee and nobody else, the ETS does not apply. And the best example of that would be a truck driver. If there's no one else in the truck with the truck driver, the ETS does not apply. It does not apply to individuals who work from home or individuals who work exclusively outside. So that would also, I believe that covers most construction workers. Next. So workplace, physical location, and the coverage is based on employees at the employer level, not individual locations. So if you have an office with 5 people and a main office with 50 and a couple other offices, then they all add up to 100. That's 100 employees, you're covered. Part-timers are counted. Independent contractors do not count. And employees who work from home, even though they're not covered, they do count towards the total. And the definition is within I believe, a calendar year. So if you are at 98 employees now, but you were at 100 or 101 in June or July, you are still covered. So there's some fine print on this. If you're worried about being on the threshold of being covered, you need to read this carefully, because just because you're under 100 now doesn't mean you're not covered by the ETS. Next slide. So you need to have a written policy on vaccines. You must implement it and you must enforce it. You have to address vaccination, exclusions to the written policy, information on determining vaccinated status, how you're going to collect it, and your part-time and leave policies for vaccinations. So next. So your exemptions. There are 2 areas of accommodations that can cause an exemption from the vaccine. They're medical and religious. OSHA points people to the American with Disabilities Act to deal with the medical exemptions, and they pointed to Title VII, a Civil Rights Act, for the religious exemptions. And there's also state and local laws you may have to accommodate. I think in New York you'll have, and I'm not an expert on this, I'm not even barely knowledgeable on that. So you need to check into that, because you may have local laws that cover medical and religious exemptions. You will also have to comply with those in addition to the federal standards. So if somebody is claiming one of these accommodations, you have to follow these laws in order to determine if the accommodation needs to be made. So next. So your policy on vaccinations. You have to have a policy for notification of employees for COVID-19 positive COVID-19 test and removal of COVID-19 positive employees. You have to have a policy for that. You have to provide that information to employees. That's to be part of your policy. The dates and the compliance with that. Proof. Your vaccination policy has to include that if an employee refuses or otherwise does not provide proof of vaccination, they have to be treated as not vaccinated. You have to keep record of each employee's vaccination status, and you have to preserve an acceptable proof of the vaccine. And then finally, you've got to maintain a roster of each employee's vaccination status. Heavy paperwork, lots of information, lots of material you have to keep as an employer to be in compliance with this. And I think the key here is that this is where OSHA is going to review. They're not going to interview your employees and ask if they're vaccinated. They're going to take a look at your paperwork to see if you've done all this. And they have to be maintained. And they have to be maintained in accordance with OSHA record keeping standards. So, next slide. So what's proof? Here are the 6 things you can have as proof. The immunization card is obviously the easiest, but there are other things you can use in lieu of the vaccination card. But you need some sort of official document, or you can actually have a written attestation from an employee saying that they are vaccinated. But that's the proof you must have and you must keep on file to be in compliance with this standard if someone is claiming to be vaccinated. Next. So, if an employee is either unvaccinated or refuses to tell you their status, every 7 days, if that person is reporting to work, they must be tested. They must provide documentation of the most recent test to you as the employer within 7 days of the test. And if somebody's been out of the workplace, let's say working at home for 2 or 3 weeks, they have to be tested prior to returning to the workplace. So, and you have to document all this. So, you are not required to pay for the test. Go to the next slide. You're not required as an employer to pay for the costs associated with testing. However, you need to be careful here because there may be other laws, there may be a collective bargaining agreement, there may be something in your employee policy, in your handbook. You're not completely off the hook for this, so be careful. There could be other federal laws, perhaps even state laws that apply here. And you are not prohibited as an employer from paying for the costs associated with testing. So you're not required to pay, but you're not prohibited from paying. Next slide. So if there's a positive COVID test, you have to notify, every employee is required to notify the employer when they receive a positive COVID test or are diagnosed with COVID. They have to be immediately removed from the workplace, and you have to keep the employee removed until they have negative tests, meet return to work criteria from CDC, or receive a return to work recommendation from a licensed healthcare provider. You are not required to provide paid time for any employee as a result of a COVID-19 test. But once again, there are other laws that may require you to do this. So once again, be careful. But OSHA's ETS does not require you to pay them. Okay? But other laws may. Next. So, masks. This only goes if you're not vaccinated. You are required to wear a face mask indoors and when occupying a vehicle with another person for work purposes, except, and here are the exceptions, when you're alone in a room, when you're eating or drinking, when you're wearing a respirator or other face mask, or when it's infeasible or creates a greater hazard. So there are exceptions to the face covering. The bottom line is that unvaccinated employees who are otherwise in the workplace need to wear a mask under the OSHA ETS. Next. So as I said, The effective date. The effective date was November 5th, 2021. That's the day the ETS was published in the Federal Register. Enforcement begins December 6th for all portions of the ETS, and testing and vaccination compliance, which that is January 4th. So in essence, the entire rule goes into effect January 4th. And as I said earlier, it's a 6-month rule. It must be replaced by a permanent OSHA standard, which goes through the formal rulemaking process. Now, this is all on hold. If for some reason, though, go to the next slide. So, should you comply? It's all on hold. Courts have put a permanent injunction on it, a permanent stay. But should you comply? So OSHA can't enforce right now. They're prohibited by the federal courts. We don't know when the courts are going to rule. Could be in weeks, there could be something by Thanksgiving, could be months. Here's the thing. If for some reason the stay is lifted and the rule is allowed to stand, OSHA will probably look at it and say, hey, you all knew this was coming. You all knew if we won, you would have to follow it. And they're not going to probably give any employers a break for not being ready under the timelines that were set by the emergency temporary standard. So, and then if you're an employer and you're covered by this, you're going to have a pretty hard time writing a plan and developing and implementing the materials that make you comply with the OSHA ETS. So, if you are covered by this ETS, I'm not a lawyer, but this is a business risk decision on your part. But just keep in mind, if you decide to take the chance that this is just going to get tossed by the courts and you're never going to have to comply, that's your call. But if for some reason it's upheld and you're covered by this, OSHA is going to expect you to have everything in place under their timelines. So this is obviously a business decision, but the safe decision is to make sure you're ready in case the courts do act. And the other thing to keep in mind, for probably most of you on the call, if you're not in construction or you're not in a hazardous line of work, you've probably never seen an OSHA compliance officer anywhere near your business. This is a rule where, let me step back. One of the 4 ways OSHA can enter a workplace is if an employee complains to OSHA about an unsafe working condition. And OSHA and the Department of Labor have already been encouraging employees to call OSHA if their employer is not complying with the ETS once it's in place. And what OSHA is going to do is they're going to come in and ask you for all your paperwork. And if you haven't recorded everything that the ETS is required, they will issue fines and citations based on the number of times you've not done what the rule requires. Those fines can be up to $13,000 per instance, except if the OSHA determines it's willful. Then it can be $130,000 per instance. So OSHA has a fairly big stick to punish with on this. And if this rule were to go through, I can see the agency making an example of a few employers to basically scare everyone else into compliance. So that's out there. And it's, until and unless the rule is struck or stayed by the courts, there's a possibility at some point it could be in place and be enforced. So, next slide. That's the very, very, very high level review of this rule. I'm happy to answer questions. I will say up front, it's a 500-page rule. I'm not familiar with the entire rule, but I am familiar with enough of it. I'm happy to answer any questions or just discuss in general your thoughts on the rule.
Yeah. So first, Tom, before I kind of poke into a question or two, thank you for all of this. It might be ambiguous, but still very helpful. So thank you. To answer 2 questions immediately for those wondering if this is going to be mailed out. So it will be posted online with all of our other blogs. So that's PrestigePEO.com/blogs. You can also reach out to any member of your Prestige service team just for further directions of how to access it, or if you just need a file sent over to you. The recording will also be there, though, so you can hear us talking. All right, so Tom, let's see what we can answer here. And everybody who has questions, listen, if we don't know, it's because no one knows. So the first question that I see here, so if you're under 100 employees, so technically not covered by the ETS, record keeping, is that just still in accordance with the ETS, or the medical records, do we or do we not keep them, or is that ambiguous to state law at that point?
That's a very good question. Because OSHA clearly in the ETS is saying that a person who's hospitalized or dies of COVID, and you and as the employer are aware, that's a reportable event on to OSHA. I'm not sure I don't know if guys can hear, but this is the time the sirens decided to come by. It very well may be a reportable event on your OSHA log. That's a really good question. I wonder if the Q&As address that. That's the first time I've ever heard that question. But no, as far as keeping the vaccine, no, the rule does not require you, if you're under 100 employees, to keep a record of the vaccination. So
yeah, so that's takeaway then. So more to come on that one. Now the next question is still a little bit also, potentially up in the air, but when it comes to medical exemptions, so somebody presenting a doctor's note preventing them from wearing a mask, I'll say this is also like deeper into the HR realm of, different workplace accommodations. I'm not sure if you have any other, guidance on the top of your brain on this one.
Yeah, this is not just OSHA. The medical exemptions are going to be the area I think they give employers the greatest headache, because obviously there are a lot of employees who don't want to get the vaccination, who don't want to wear a mask. And if you're presented with, a doctor saying, this person can't wear a mask because it would harm them, they have a medical condition. Now you're talking about accommodations, you're getting into ADA, you're getting into HR world. This is going to be a huge headache for employers, and there's just no easy answer. There's no easy answer. Which is, I think, one of the challenges to the case is the fact that so much of this is arbitrary and unclear, that compliance is not possible. So that's actually one of the arguments it's being argued in court against the rule.
Right. And I feel like the stock response has to be, it's on a case-by-case basis.
Yes.
Because everything's dependent on so many factors. So if you ask that question, if you run into the situation, let us know, talk to your HR business partner. If we need to pull in additional resources, we will. And, we'll partner with you to look at each individual situation. All right. So, Tom, it looks like that is the extent of the questions so far. I'm sure some might trickle in afterwards today as everyone reviews what was discussed today, because this was awesome.
So, and part of this is this is really so totally up in the air. In 4 weeks, this may be an artifact of something that never happened, or in 4 weeks, everyone may be scrambling to try to comply with this. It's just we don't know yet, and I can only apologize for that. But the courts are the courts, and they're going to work on this.
Of course. And listen, we thank you so much for coming on and still just keeping the lines of communication open, letting us know what's coming down the pike. It's the best way for us to remain prepared. So the work does not go unnoticed. So thank you again for just the time this morning.
Oh, no problem. And good luck, everyone.
Why, thank you. As for those who are here, so as always, like mentioned before, you can find everything online. We also have a dedicated website for the webinars, not just on the blog, right? So prestigepeo.com/webinars. Please keep your eye out for our Insights communications. Connect with us on socials. We have our podcast. Please let us know the items that you continue to want to hear about so that we can just keep this as catered to your needs as possible. But as always, thank you for jumping on and sharing your Wednesday morning with me and the rest of us here at Prestige. And until next time, have a wonderful rest of your week.